Washington.
Thank you, Judge. As the court knows, summary judgment is limited to the evidence that's been submitted in the briefing before the court. Mr. Romo, as of yet, has not filed a response, and so there's no controverting evidence in the record other than what Move and Elect Energy has filed with the court. So I just wanted to at least clean that up for the court as far as the housekeeping matter is concerned. Judge, this is a breach of contract case. My client, Elect Energy, had hired Mr. Romo as a 1099 contractor, and Elect Energy is in the business of selling energy contracts to end users and being paid by energy providers for those contracts. They have contractors such as Mr. Romo who will go out and sell those deals and will make commissions based on those sales that he makes. Now, part of the deal with this is that the provider will pay Elect Energy for an estimated kilowatt usage over the course of the contract that is sold. And they'll pay Elect Energy up front for that. Elect Energy then in turn would pay its sales reps, like Mr. Romo, their commissions up front for these contracts. Now, many times these contracts, either the end user cancels their contract or defaults on their contract with the provider, or the kilowatt usage is not as much as it was estimated at the beginning. And so then the provider, the electric provider, claws back a portion of those commissions or those payments from Elect Energy. And Elect Energy does the same for its 1099 sales reps. And so, Your Honor, what we have here, the evidence that's been put in the record, Mr. Romo had sold a contract to an end user, with a provider called ENGIE, E-N-G-I-E. And in the course of 2020 and 2021, there were clawbacks made by ENGIE, and that is contained as our Exhibit 1C to our motion. Those clawbacks occurred. Elect Energy was liable for those clawbacks, and in turn, pursuant to Mr. Romo's contract, he was liable to pay back his 20% commission for those clawbacks. And that amount, Your Honor, as shown from the Exhibit 1C to our motion, is $309,638.64. Now, pursuant to the agreement between Mr. Romo and Elect Energy, he can either pay those commissions back directly, or he can have those credited against future commissions that he earns while working for Elect Energy. After this clawback period occurred, Mr. Romo ceased working for the company, and after a demand was sent in February of this year to pay back those amounts, Mr. Romo did not do so. So, Your Honor, based on Mr. Sean Roan's affidavit, the exhibits including Mr. Romo's contract with Elect Energy, the clawback calculations, which are submitted through a business records affidavit from Elect Energy, and the facts contained in Mr. Roan's affidavit explaining the story of what happened here, we have met our burden to prove as a matter of law that Mr. Romo did in fact breach this contract by not repaying the commissions he was required to repay. And because we've also fulfilled our obligations under Texas rules, Civil Practices and Remedies Code 38001 by sending a demand letter to Mr. Romo for which he did not satisfy the amounts that were due, Elect Energy is also owed its reasonable and necessary attorney's fees, which are included in our motion as Exhibit 2, my affidavit, Exhibit 2B, which has our invoices included in it. Now, I will say in our motion, we've submitted that we are asking for $13,930.17 in preparation or in pursuing and prosecuting this claim. We did have in the motion an estimated $3,500 in preparing for this hearing. However, because Mr. Romo did not file a response, so there was no review for that, and there was no time spent drafting a reply brief, we would submit to the court that $1,800 would be a more reasonable estimate for the amount of time and hours that I've spent preparing for and attending this hearing.
Response?
From me, sir?
Yes.
Oh, okay. Well, a lot of those accounts, so those weren't sold personally by me. There were sales reps, which they haven't been brought up here. Juan Galvan and his team from down here in the Rio Grande Valley. There were sales reps under me that I had brought in, that I was referred to, and they're the ones that wrote all these deals that we're talking about. So my question is, when I spoke to Rhonda last month, I haven't hired an attorney, sir, and I wanted to be able to get an attorney because it's a little confusing because I understand on my personal deals, I can, I have chargeback, but none of these deals were written by me. They were written by that sales team. So I want to know exactly and investigate further, like what happened that all these chargebacks happened. Most of these deals that they wrote, they all went down south, So I'm trying to find out what happened, why did they cancel, but I did not write it personally. It was the sales team. Yes, I got an override from them, but I don't know exactly, it's just Sean called me one day that all these accounts were canceled. I don't have communication with Juan or that sales team anymore. So my question is if I could get an attorney so that they can help me to figure this out more, or if I don't even know if I could go and contact Juan because of this lawsuit or to find out. So I'm asking just Your Honor if I can get an attorney or to investigate this further.
Response?
Well, Your Honor, Mr. Romo filed an answer in this lawsuit, and quite frankly, there's been no response on file. There's no controverting evidence that's here, and there's been no request formally through written motion for a motion for continuance or anything of the sort. So, Judge, I think it's pretty clear from the summary judgment record that the court is able to grant our motion for summary judgment because there are no undisputed facts or objections on file for the evidence that's been put forth in our motion, and we've met our burden.
So, Mr. Romo, this is kind of a tough call, I admit. So they filed a summary judgment which would resolve the case. Have you tried to talk to an attorney, or did you just kind of?
Well, I did talk to one, but he was charging so much money I couldn't afford that money. But he told me that after January that he didn't have any more cases, he could help me out just to get the information that I needed, because I don't understand how this civil lawsuit worked. But my thing is, like, when Sean sent me, told me that all the deals canceled, then I saw this going on with the civil lawsuit that I wrote all these deals. I didn't write none of these deals personally. They were written by the sales team. I got an override on my contract with Sean. It shows there that you have there that any deal that I write personally, it's the chargeback of mine and that I have to pay back. But since they weren't written by me, they were written by the other guys. I wanted to find out, like, what really happened. Did any of these contracts actually stay on board? I don't have any access to those because only Sean has communication with those supplier companies, light companies. So I'm just trying to find out. I thought with Rhonda I was going to have a trial going on for next October or something like that next year, so it would give me time to come up with the money, get the attorney, and then I got this letter that for this summary judgment, which I wasn't aware of.
Judge, may I respond?
Sure.
Your Honor, this case was filed in March of this year. The summary judgment was filed September 15th of this year. So Mr. Romo's had 3 months since the filing of the summary judgment motion to find a lawyer or to even reach out and talk to us about asking for a continuance or anything like that. But at this point, my client spent the money to have this summary judgment hearing, and procedurally, Mr. Romo hasn't filed anything that would oppose what we've put into the record.
It's because I didn't understand, sir. How it worked. All right.
So, unfortunately, as a judge, I don't have a whole lot of options here. I have to kind of, just like everyone else, I have to obey the law, and the law is that you didn't follow the correct procedure. Now, I will say this, that if you want to file what's called a motion to reconsider or a motion for new trial, you would have time to get an attorney to possibly get this overturned. I have had people in this situation. You only have a very limited amount of time to do that. And so I have seen people before in your situation. I'm not saying, I don't know you at all, sir, so I'm not suggesting you'll do this, but that kind of stick their head in the sand and think, oh, this is just going to go away. And a judgment like this can really haunt you for quite a while. It stays in effect up to 20 years and even longer sometimes. And so I'd highly recommend, you sound like you're a fairly high wage earner. You probably have some assets that you don't just ignore this. And so I would reach out to an attorney immediately and say, hey, look, I need to get a motion for new trial on file. But unfortunately, because you haven't followed the correct procedure, I don't really have a lot of options here. So do you have any questions, Mr. Romo?
So I just didn't understand how this was going. I really thought that it was going to go for trial. The first time I did talk to an attorney, he's the one who helped me fill out my response to you, when I first, got the lawsuit. And I paid him, $400, and he helped me write the letter and submitted it for me to y'all. And then after that, I just, I didn't have an attorney. So I thought, well, eventually it'll go to a trial. I'll have time, because I would talk to other people. So when I did, talk to Rhonda a few months ago, last month, and she said, okay, it's going to be set for trial. And so I thought it was I got that email for next year. I said, okay, well, after January, I'm able to talk to this attorney and get him so I can start, working on it. But this really did throw me off a little bit. I didn't understand how it worked. And
well, I can't give you legal advice, but this is, if you don't get something on file very quickly to try to get a new trial, and I would get an attorney right away, this judgment will become final, and it's something that could be around for a long, long time. They may try to execute on your assets. And so I just want to make sure there's no misunderstanding here that I don't have any choice but to sign this. You do have one last opportunity to fight it by filing this motion and getting an attorney, but you got to do it right away. So
okay. Like this week right away, like
I can't give you
okay.
You can look that up, but it needs to be right away. So time is of the essence. You have a limited amount of time to do this, and don't say, well, I had the Christmas holidays and therefore I didn't do anything, because this is a judgment that could, I'll be honest, Mr. Pennington, this sounds like a very strange way to pay people, but he didn't file a response. And so I imagine a good attorney could have fought this, but I don't know all the details. And so it just does sound like a very strange way to handle this type of issue. But again, I don't know the contracts. I don't know all the issues. So, but Mr. Roma, I wish you the best of luck. Do not put your head in, my suggestion to you is not to put your head in the sand, because.
Okay. No, I'll after this, I'll go talk to him right now. And I honestly did think it was going to be for next year, but I'm sorry. I just didn't understand how all this works. So my apologies, but
that's all right. That's all right. Well, we wish you the best of luck. Okay.
Okay, sir.
All right. Thank you.
Thank you.
Thank you, Judge. And we have a proposed order on file that should be.
I printed it out. I'll try to sign it this week.
Thank you, Your Honor.
Thank you. You guys have a good day.
You too, sir.